Thank you, and enjoy the rest of your day.
Thank you very much, Andy. And so now, in a change to our advertised schedule, we're just going to have a little reprise. And in fact, we're going to go back to where we hoped to be earlier in the day with Professor Adam Candebub from the Michigan State University. And Adam's going to take maybe a slightly different angle on the one we heard earlier from Brad about the court case. So over to you, Adam.
Well, thank you very much. And I regret any confusion in the beginning. Next slide. Yeah, so I'm sorry it's a long day, and I'm not going to make things more exciting by talking about law, but I think everything that was said in the last hour or two is quite relevant, or potentially relevant, to the cases the Supreme Court will decide in a few months. It is, as was mentioned before, the Free Speech Coalition v. Paxton, which challenged the age verification requirements in Texas's HB 1181. The reason why it's so important is because if the court approves this law, there are 20 other states that have similar ones, and there will be a tremendous market for age verification. And that's very important, of course, to you all. But also, I think what you have to tell the Supreme Court about how age verification works now, as opposed to the way it worked in 2004, when the court last looked at this issue, is very, very important. And I will start and I will end with a plea. Those of us who are trying to defend the Texas law before the Supreme Court, we need amicus briefs. And Ian's group has done a tremendous one. It's a great document. But the court generally looks even more favorably upon academics. Not because we're great or anything, but because we're just viewed as rightly or wrongly as not having an agenda. And I have struck out in trying to find academics who can, or sort of independent researchers who can write about this. And really, as we'll see, what needs to be written is pretty much a summary of the presentations today, showing that contrary to what was decided in Ashcroft, age verification is not burdensome. It's cheap. It does not disclose identity. It does not lead to the hoarding of biometric data or financial data, which was an assumption, as we will see in the Supreme Court's decision in Ashcroft, which essentially de facto struck down the federal age verification law passed in the early 2000s. Okay, so just quickly, the Free Speech Coalition, I don't want to go over stuff that Brad did a better job explaining than I could. The Fifth Circuit, which is the appellate court right below the Supreme Court, upheld the Texas's law that required age verification for children accessing porn, or to prevent children from accessing porn. And it was a tendentious decision. I concede that. Please don't quote me on that. Because what it said is it used a rational basis, a deferential standard of review, to determine that pretty much any law that regulated speech, regulated obscenity, would be constitutional. So it upheld the law because obscene speech is not protected. So what will the Supreme Court do when it gets this case? It has two choices. One is the nothing burger option. It will punt and will say, oh, Court of Appeals, you used the wrong standard of review. A higher scrutiny applies. Apply the scrutiny and get back to us, in which case we'll all be in the same place in 2 years. Or it could just say, okay, it applies the correct standard of scrutiny and decides the merits, and that would be a big deal because, as I said, it would determine the constitutionality of all these cases. Okay, Now, as I said, rational basis is this very low standard. It means any conceivable reason that a judge can think of for why a legislature would pass a law is okay. And the Fifth Circuit said, we accept the law under the standard. Next slide, please. And the problem is that, the older everyone thought before the Fifth Circuit that this higher standard would apply, called strict scrutiny. And that's what the court applied in the previous age verification case, Ashcroft v. ACLU. And when a court reviews a statute on strict scrutiny, it's a much more rigorous inquiry. The statute must advance a compelling state interest and must be narrowly tailored, meaning it must focus only on the prohibited speech, that government has a compelling interest to do so, and as little burden on other possible speech. And there has to be no restrictive alternative. Okay, next slide. So, in the last time the court looked at age verification, they said, well, look, this law gets strict scrutiny, in a ruling that is in tension with the Fifth Circuit's rational basis scrutiny, and then said, look, this federal law that requires AV, it doesn't pass strict scrutiny. Why? Well, for a variety of reasons. One is an esoteric legal issue that I'm sure none of you care about, and I had to drink several cups of coffee in order to care about, which is the definition of obscenity and whether it was broader or lesser. But the other reason, which is directly related to all of your interests, is that they said the burden on adult speech, on lawful, non-obscene adult speech, was too great. Why? Because there's plenty of sort of racy sexual material that's not obscene, that adults have a right to receive, and the court was very, very concerned about the monetary costs and potential embarrassment that could deter potential viewers, and in that sense, the statute's requirement may restrict access to a site. And that's a quote from Justice Breyer. So they were really concerned about, well, we don't want, essentially, the founders of the American Republic were really concerned about the, the false feeling of being anonymous while browsing porn on the internet. So if we're going to win, if the court does go to the merits, that's the one if, and if we're going to win, we have to show that AV doesn't really burden adult speech in the same way that Ashcroft did. And Ashcroft was quite explicit. It bemoaned, having to show your credit card numbers or your government ID, which again in 2004, when Ashcroft was decided, was a big deal. I mean, I still remember, my mom refused to put her credit card on the internet until I think 2012. So, the court is really coming from a different time, and really needs your knowledge, your education to sort of say, look, there are ways that do this that do not impinge upon privacy, that do not impinge upon autonomy, that people can do, I think that's your phrase, is frictionless and without cost. And we need someone who doesn't have an apparent interest, who doesn't have a dog in the fight, who'd be willing to sign it. And we can get it written, we can help with all the legal stuff. But I mean, I hope I don't abuse Ian's very kind invitation by asking if anyone is out there interested to please contact me, because I think we could write something that the court would find very useful. So thank you. That's it.
Thank you very much.